One afternoon, a quiet case was moving along like any other. Documents being passed, statements being made, nothing unusual on the surface. At the plaintiff's table sat a man in his mid-40s, calm, organized, speaking clearly as he explained his claim. Across from him sat a younger man, early 30s, slightly tense but composed enough to respond when needed. The case was about a car. The plaintiff claimed he had sold his vehicle to the defendant, received only partial payment, and was now owed the remaining $5,000. Simple, on paper. When asked to speak, the plaintiff laid everything out neatly. "I transferred the car to him," he said. "He paid half up front and agreed to pay the rest within 2 weeks." The judge nodded. "Do you have a written agreement?" "Yes." The document appeared on the screen, signed, dated. Payment terms clearly stated. The judge read it, then looked up. "And you received partial payment?" "Yes." She turned to the defendant. "Your response?" The younger man leaned forward slightly. "I paid what I owed," he said. The room shifted. The judge raised an eyebrow. "You paid the full amount?" "Yes." The plaintiff shook his head immediately. "That's not true." The judge held up a hand, one at a time. She turned back to the defendant. "Do you have proof of full payment?" The man nodded. "Yes." He handed over bank transfer records. The clerk displayed them, several transfers, amounts that added up close to the total. The judge leaned forward slightly. "Close is not exact," she said. The man frowned. "It's all there," he insisted. The judge didn't respond immediately. She began reviewing the transactions carefully, dates, amounts, descriptions. Then she paused, not dramatically, just stopped. Her eyes moved back to one specific line, then to another, then back again. Something didn't align. She leaned in slightly closer. The room grew quiet, because this wasn't confusion. This was recognition. The judge looked up, then back down at the screen, then at the defendant. "How many payments did you make?" she asked. "5, he said. The judge nodded slowly. "And these were all for the car?" "Yes." The judge's eyes didn't leave him. "Then why," she asked calmly, "are 2 of these payments dated before the contract was signed?" The room froze. The defendant blinked. The plaintiff frowned. The judge didn't move, because in that moment, something small, something easy to miss, had just changed everything. The silence didn't just linger. It tightened. The defendant looked at the screen, then back at the judge, then down again. I paid him before," he said. The judge didn't react. "Before what?" she asked. "Before the contract," he replied. The judge nodded slowly. "So those payments weren't part of this agreement?" The man hesitated. "They were for the car," he insisted. The judge leaned back slightly. "But the contract defines the transaction," she said. "Anything before that is not automatically included unless clearly stated." The plaintiff stepped forward slightly. "That's exactly right," he said. "Those earlier payments were for something else." The judge turned to him. "What were they for?" The plaintiff didn't hesitate. "Repairs," he said. "He asked me to fix the car before buying it." The defendant shook his head quickly. "No, that's not true." The judge raised a hand. "Stop." The room settled again. She looked back at the records, then at the contract, then at both of them. "Let me understand this clearly," she said. Her tone was calm but precise. "You made payments before the contract existed." She looked at the defendant. "Yes." "You claim those were for the purchase?" "Yes." She turned to the plaintiff. "You claim they were for repairs?" "Yes." The judge nodded once. "Then the question becomes simple." A pause. "Where is that reflected in the agreement?" The room went still, because both answers depended on that one point. The judge tapped the contract lightly. "This document outlines the payment structure," she said. Half up front, half within 2 weeks. She looked at the defendant. Does it mention prior payments? He hesitated. No. She turned to the plaintiff. Does it mention crediting earlier amounts? No. The judge leaned back. Then those payments are separate. The statement landed clearly. The defendant frowned. But that's not fair, he said. The judge didn't respond to the emotion. She responded to the structure. Fairness is not the issue, she said. Clarity is. A pause. You entered into a new agreement. She pointed to the contract. And this agreement defines what counts. The defendant looked down. Because now his own evidence was working against him. The judge continued. You cannot retroactively assign earlier payments to a later contract without documentation. The room stayed silent. The plaintiff remained still because the direction was now clear. The judge leaned forward slightly. You agreed to pay a specific amount under this contract, she said. Yes, the defendant admitted, and you have not shown proof that this contract was fully satisfied. The defendant didn't answer because he couldn't. The judge sat back. I am ruling in favor of the plaintiff. The words came clean. Final. You owe the remaining $5,000. The defendant exhaled slowly. The plaintiff nodded once, not in celebration, just confirmation. The judge wasn't finished. This case turned on one detail, she said. A pause. The timing of your payments. The room stayed quiet because that was exactly what had changed everything. She gathered her papers. Case concluded. The gavel came down, short, definitive, and just like that, a case that looked settled was completely undone by something that didn't add up until the judge stopped long enough to notice it. They stepped out into the hallway, but this time neither of them walked ahead. They stopped almost at the same moment, like both of them needed a second to process what had just happened. The defendant looked down at the papers in his hand. 5,000. He shook his head slightly. I thought that covered it, he said. His voice wasn't defensive anymore, just tired. The plaintiff leaned against the wall. It didn't, he replied. No sharpness, no satisfaction, just fact. A pause settled between them. People passed by, but neither moved. You should have said something earlier, the defendant added. The plaintiff nodded slightly. I thought the contract made it clear. Another pause, because now they both realized the same thing. They had assumed different meanings from the same situation, without ever lining them up. I paid you before, the defendant said. I thought it counted. You paid me for something else, the plaintiff replied. The difference, simple but critical. The defendant exhaled slowly. I should have written it down, he said. Yes, the plaintiff replied. No hesitation, no argument, just agreement. They stood there for a moment longer. Then the defendant folded the paper carefully and slipped it into his pocket. I'll pay it, he said. The plaintiff gave a small nod. I know. There was no tension left in that statement, just expectation, because at this point, the case wasn't about proving anything anymore. It had already been decided. It was about follow-through. The defendant looked up briefly. All of this over dates, he said. The plaintiff shook his head slightly. Not just dates, he replied. A pause, over not being clear. That landed, because that's what it really was. Not the money, not the car, clarity, or the lack of it. After a moment, the plaintiff stepped away from the wall. Take care of it, he said. I will. And this time, there was no doubt in it. The plaintiff nodded once, then walked down the hallway. The defendant stayed where he was for a second longer, then turned in the opposite direction because the case was over. But the lesson was still settling in. That sometimes it's not the big arguments that decide everything. It's the small detail no one thinks to question until someone finally does. He stepped outside the courthouse, the late afternoon light hitting his face as he paused at the top of the steps. For a moment, he didn't move. He just stood there, thinking. $5,000. Not because he didn't pay, but because he didn't define what those payments meant. He reached into his pocket, pulled out his phone, and opened his banking app again. Scrolled through the past transfers. There they were, dates, amounts, clear to him, but not clear in the way that mattered, not tied to anything, not labeled properly, not connected to the agreement that came later. He shook his head slightly. All of that and none of it counted, he muttered. But even as he said it, he knew that wasn't true. It counted, just not in the way he thought, because the moment the contract was signed, everything before it became separate, unless it was written in, and it wasn't. He locked his phone and slipped it back into his pocket, then took a step forward. Then another. No rush, no frustration left. Just understanding. Across the street, cars moved like nothing had changed, because for everyone else, nothing had. But for him, one detail had shifted everything. He reached the curb and stopped again, looked back once at the courthouse, then turned forward, because now there was nothing left to argue, nothing left to question, just something to complete. $5,000, not as a surprise, not as a loss, but as the result of something simple, a moment where clarity should have existed and didn't. He stepped off the curb and kept walking. And for the first time since the case began, everything made sense exactly the way it should have from the start.